I have a secret. I've been hiding from you all day.
Oh, really?
What? Somebody's not paying us?
No, worse. So I
It's
got...
not worse.
They're true. So I had to get dressed in the dark today. And I went into my sock drawer, and instead of taking my dress socks, I took out the I Love French Bulldog socks.
I can live with that.
You can't? Okay, good.
Yeah, no, that's good.
Okay, good. Good. Phew. All day I've been hiding socks. It's not
You're a very
office.
big sock critic, actually.
Yeah.
So I started working when I was 13 years of age. I told you the joke of how, you know, I worked at Baskin Robbins at 13. I got yelled at because my scoops were too big. And he couldn't make a living off of my scoops. And then I mowed lawns and did all sorts of stuff. I've driven a tour boat. One of my favorite jobs at 17 was selling suits, shirts and ties and suits. And then I got lucky enough to be at Breton's, where I was under the sort of tutelage of a general manager who was brought in from Britain, who was like an impeccable dresser.
Young and Bloor? No.
No, actually at the Promenade, when it was actually a mall you wanted to go to.
That's right.
And, you know, he taught me that how to put together a suit, shirt, and tie. And he goes, you know, it's clear the socks have to match relatively close in color to your trousers. Period.
Oh, boy. Wow,
right?
Great.
And Diana has been very kind when we message clients and say, tomorrow we're coming up. If you're hearing, please make sure you're in a suit, shirt, and tie. And please make sure you don't wear white socks.
Yeah,
Yes.
that's my added.
Otherwise, you're gonna hear from Joseph for an hour
hear the end of
why
it.
you can't wear white socks with your suit.
Oh, I got worse than that. One of my first clients, lovely Jamaican lady, very religious, church every Sunday. So when we were going to finish her case off, I said, dress as if you were going to church and you'll be fine. She shows up at Old City Hall Court wearing the brightest peach-colored dress with little chiffony white things and an umbrella. I said, okay.
Well, that's church in Kingston, Jamaica.
That's right. That's right.
There's nothing along with peach color.
There isn't. I love peach. It was great. The judge just smiled.
It's fine. And,
Yeah,
and you know, when you dress like you have some respect for the
Right.
court, it's good.
They
and,
get
you know,
it.
as we say to clients, it's a very serious event. So you want to dress with respect to the court.
That's right. That's right.
So those socks will pass for the podcast tonight.
Right.
And the only thing worse than not being paid is losing.
Yeah, I know.
We don't like to lose.
No, we don't like to lose.
No.
So
But we
let's
do
talk.
like listening to the people who watch our podcast.
We do.
Excellent point. So somebody wrote, and I think it was one of our short clips, which was posted on X, or TikTok. I can't remember which one. Who asked, can you do an episode on consent and on whether you can record consent to protect yourself? And so I didn't get much more clarity, but because we like the comments coming in, people are engaging, we thought it would be a good opportunity to review what consent is in law, and can you make any type of recording or any effort to obtain consent, and what are the legalities around that?
And, you know, to be fair, it sounds very simple. And a lot of people say, well, yes means yes and no means no. It's like, but it actually has become quite complicated to understand, one, what comprises communicated consent, and then what would negate that consent. There are some factors that can vitiate consent. So that's what we're going to
And we've had questions about advance consent. Can you consent in advance?
Right, yeah.
Let's not complicate it too much at the moment, because you're right, Diana. So, you know, it's communicated consent at the time of the sexual acts for each sexual act undertaken.
When it progresses, it doesn't have to be if you get permission to undo a button, you can keep undoing buttons.
Right.
But if you're going to move on to something a little more drastic, then you need to
Like a
check
belt.
in. You need to,
Or socks?
yeah. You need to check in when the activity changes in nature, substantially changes in nature. And so there was a seminal case called Iwanchuk, which kind of started to outline consent, and that's kind of, you know, the main one that gets referenced. You know,
1999, 1 SCR 330.
And so this was a case in which the complainant had gone for a job interview and then was uncomfortable going into a trailer with the interviewer and tried to leave the door open. The door got shut. She kept on saying no when he was making advances. And so that's an important point to stop at, because if it comes out that a person said no, they can change their mind.
Of course.
But it's going to be expected quite often that you take extra steps to make sure that the no properly changed into a yes. And so in this case, she kept on saying no, 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 and then stopped saying anything because there was a fear involved in terms of her thinking that the door had been locked. Mm-hmm. And so that's another important point that came out of 𝐈𝐴𝐏, is that a lack of no, a lack of resistance, a failure to say anything. And, this includes having consented but changed their mind. They're not required to verbally say that they changed your mind. You're supposed to be attuned to the body language and be able to show how the consent was being communicated to you.
And consent is subjective.
That was a big factor in this case.
So let's explain that a little bit more. So consent is subjective to the state of mind of the complainant. Let's expand on that a little bit more.
So, what that means is that only one person can know if the complainant was consenting, and that's the person who owns the mind.
Complainant.
That's right.
The person who is experiencing that thought or emotion. And so other people might think they know what that person was feeling or thinking, but only the complainant can say whether or not in their mind they were actually consenting. So it's
actual state of mind of the complainant is what the case say.
Correct. And the actus reus and mens rea, state of mind of the accused is secondary as a consideration.
Right.
Recklessness undermines the mens rea argument.
Right.
And let's leave aside the stuff about advanced consent.
Yeah, that's getting
But the way to deal with subjective consent is, so the complainant at trial, because ultimately all this is litigated at a proceeding where obviously it's an allegation of sexual assault, will say about what their state of mind was with respect to consent.
Right.
This is that. Just to pause for a moment on that, though. Yeah. This is important for people to understand, because that's why people get charged so easily, is that the complainant will make a complaint and say that they were not consenting, and it's assumed, because it's subjective, that what they're saying is true.
Correct.
And then the rest goes forward.
Leaving aside the policy that they don't disbelieve what a complainant says.
But it doesn't mean that just because a complainant, who is the owner of the mind, says that they didn't consent, that it makes it true. Right. So it's still subject, even with 𝐈𝐴𝐏, it's still, and they make that clear, subject to a credibility assessment, whether or not they're believed.
And so you deal with that by way of an accused testifying, and also through cross-examination of actions, words, and other circumstances that would undermine the lack of consent. And that's why we also have the burden, which we have to put into context here, is the Crown has to prove beyond a reasonable doubt lack of consent.
So they have to prove that touching took place, it was sexual in nature, and that the complainant did not consent. So the complainant must be believed beyond a reasonable doubt that the consent did not exist. If they're believed that there was no consent, that still doesn't necessarily mean that you're guilty of sexual assault, because you still have left. There was an interesting line in here too, saying that
the mens rea,
that mistaken belief, like belief in consent exists. As soon as you're challenging consent, you're arguing that the accused believed they had consent, but then we get into mistaken belief. And that's where the state of mind of the accused person then becomes relevant. Like you said, it's the second consideration.
Yeah, and we did a whole podcast on that, and I don't want to go into it because we could be here for like 2 hours because we covered it. It's very, very complicated. But it's very important to be clear that consent still remains, it's communicated consent at the time of the sexual actions, and consent is a subjective concept, but it can be addressed through words and actions of the complainant that you can establish through cross-examination and through the testimony of the accused.
And despite the pressure for ongoing enthusiastic verbal consent, that is not the law yet.
Just talk about that for a second, because we've had that happen a few times where the Crown was actually arguing that there should be enthusiastic consent. We've said that a long time. What does that mean? Yeah. Are there pom-poms that come out and you're going, yeah.
Cheerleaders.
So it's like, verbal consent is one thing, but there's actually some pressure to make it that the consent can't just be, sure, it's got to be enthusiastic. Yeah. And, but of course that only applies to women, when they talk about enthusiastic consent. And, and again, it's just not practical in terms of the way people actually communicate. And communication in Canada still includes actions. And that's important to know, that actions, if they're believed,
Say that slowly.
Very slowly.
if it's believed that the complainant was taking certain actions that would communicate consent, then that's still a valid form of consent. It does not need to be verbal,
Right.
and it most certainly does not have to be enthusiastic.
Right. So consent can be communicated through words or actions. And thank God there's no requirement for enthusiasm.
Yeah. Or we'd all, that'd be problems.
Well, we did have that one client who just said, what was the word? She was very cheerful.
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 How did you know
works.
she was consenting? Well, she was very
was
cheerful.
cheerful.
So anyway,
That was funny.
Well, that reminds me though of an interesting case that came up in Ontario, in which the person, this is the JC case actually, it was Ontario Court of Appeal, and we've talked about this case quite a bit, but it's
Well, JC is a pivotal, important case.
so in this case, because we were just talking about enthusiastic consent, this is a case in which the accused person testified that consent was actually an active, ongoing process at every phase and throughout the entire encounter. And the trial judge just went, well, that defies common sense. This isn't the way people act. And so he ended up being convicted because the judge specifically did not believe that his the actions described accorded with human behavior. And so this ended up being sent back to trial again, saying that that was an error that was ungrounded about, assuming that certain people behave or do not
Certain
behave in
ways,
other ways, but also made the point that rejecting it because it was too perfect to be true, this was behavior that we actually encourage people to engage in.
Yeah, so let's slow this down for a second. So we're going back in time. We've covered this a long time ago, but it's very interesting.
It's a good case, though.
So the judge rejected the accused evidence specifically because the judge found that the accused evidence about carefully staged and sequential inquiries into consent defies actual human behavior and is contrived. Overall, the accused evidence was self-serving and designed to explain what I find inexplicable, at least as it relates to the latter two accounts. But it was about how this particular accused said, I was paying attention to the complainant and seeking consent at every stage of or phase of what we were doing.
Right.
Now, I have sympathy for how the judge might go, well, that's not how people have sex. That's not how people engage in real life. I get that. But that's not a reason to reject it.
Right.
And there are people we found who will try very hard to ensure that they are checking in tune, and getting that consent, because frankly, that's what the fucking law demands.
That's what people are being told to
That's right.
Taught to do
now. And, even though it's not completely necessary for verbal consent, but somebody may do that because that's what, basically, especially at universities.
Yeah, university. Yes.
They're saying that, this is the way you should obtain it.
But again, I want to say I have sympathy because we've often argued, and I've said this before, that we are robbing, the human nature aspect of what interpersonal relations are, particularly in the most intimate situation you can think of, where people will be engaging in a flow and organic development of how they're interacting in an intimate setting. I agree. Sometimes things could seem too staged. I get that. But people do that. And that's not a reason to I always have an offspring calling during my podcasts. Sorry, just one second.
That case is...
Hang on. Rachel, I'm shooting the podcast, honey. Is there something you want to say? Like, share, subscribe?
Like, share, subscribe, and post it on your Instagram with a link.
Not bad. Thank you. Is everything okay?
Yeah, I'm just going to go. I just got off work. I didn't have a break, so I'm going to sign the thing now, and then I'm going to go get my friend and bring her over.
Thank you. I love you. Bye.
Bye.
So the
At least
case
we got an advertisement out of it.
Yeah.
The case we were talking about is RVJC 2021 ONCA 131. And it's full of, we've talked about this case a number of times, but it was just really interesting in terms of people understanding consent, because a lot of people really do think that, if the person's smiling and they're not saying anything, then that's friendly and that's consent.
That's consent.
Not quite good enough. But then also we have the opposite side of the spectrum, where if you go about tediously getting consent, then it could end up, being hard for people to believe. You have to, but people do it, and that's what they're encouraged to do. So what can you say?
And the appeal in JC was about, ungrounded common sense assumptions and and stereotypical inferences. And we've sort of come around with Kruk, where you can use common sense again.
Right.
But I'm still of the firm legal opinion that to assume that somebody who checks in and tries to obtain consent at various phases, and to say that that doesn't accord with human nature, would be an ungrounded assumption and would be a discriminatory or stereotypical inference. Because it happens both ways.
Yeah.
It is such a varied and nuanced approach that's necessary here that you've got to be careful about your analysis.
There is an interesting factor too, where there's a lot of cases where it's argued that if you don't know the person very well, if you've just met and you just started dating,
that's a good point.
The requirement
Higher.
to seek consent more carefully, goes up, and then the longer you've known somebody, then the more you have sort of a routine with each other. But then, interestingly, when we have cases with long-term stuff, they say that you can't talk about what the habits were because
You can't. You need an application.
Then you're assuming.
Yeah.
So So I understand why people get confused about consent, because what should be simple is unfortunately very, very complicated, and it's always case unique.
This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record. And now back to our podcast. Thank you. This is something worth spending a moment on because it was an interesting question about consent. So where you have a couple who's been together for a prolonged period of time, you have a familiarity, a routine. Let's not say it's like wash, rinse, repeat, but you have, sort of a way that you engage with each other. So one can imagine on a 276 application, evidence of other sexual activity that goes to how you communicate consent is relevant. But we have to bring an application and, argue successfully that it's relevant. And I think if framed properly and grounded in the evidence, you can do that. But it's very interesting that regardless of whether it's a situation where you just met or an ongoing relationship, the argument will still be, well, it's at that time and all that other stuff is irrelevant.
Yeah.
And it's not.
It's not. Yeah.
And I do intuitively somehow agree that if you don't know each other, right, you just met, you may want to be a little bit more careful.
Due diligence, yeah.
A little bit more careful. But we all know from human nature and how, without saying much, we've all been there. In a short period of time, you can sort of connect with somebody pretty quickly and read them and know what's going on, and you can get, a rich or sort of robust amount of evidence out of that interaction to get across to the court through testimony or cross-examination what would have been actions or words that would have grounded your belief in consent, and in fact, rebut the fact that there's no consent.
Right.
There are some factors that even if the person consented, their consent can be vitiated, can be nullified by a few factors.
Oh, there's a few, all right.
Yeah.
Right. And I don't know if we should, you can go into it briefly right now, but
intoxication is one of the big ones. And there's a really big misunderstanding, as we've covered before, about what level of intoxication is required before you're not capable of consenting. And this is you have to be extremely intoxicated before your consent is no longer valid. Right. And there's a big misunderstanding and miseducation, I think, especially at universities, about
100%,
what that level is.
a complete misunderstanding and an intentional miseducation of students about what consent is on f***ing purpose for a narrative that's not it's not correct.
And it's unfortunate, not just for the people who end up being accused by somebody who sincerely believes that they weren't legally able to consent, but it's also very unfortunate for complainants who have to go through these big trials and then find out that they were still responsible for their consent and their behavior. It's unpleasant for both sides. So
we've heard it umpteen times when we've dealt with university cases. well, I had some drinks, therefore I'm incapable of consenting, and he should have known that.
I know. There's
If I was
big
sober,
misunderstanding.
then I'm capable of consenting. But because I had
Yeah.
drinks, I can't.
Right.
Yeah.
He should have known that.
I would have made different choices if I'd been completely sober. We've actually heard that phrase, completely sober.
Yeah, no, this is not like a one-off. This has been throughout. And the university education, unfortunately, through orientation on this, is completely misleading and puts students at risk. And, our advice to male students or female students, depending upon it, you're probably better off not having any type of intimate contact when anybody's drinking because of the complete misinformation out there.
And then you'd mentioned earlier, too, advanced consent. So people can withdraw their consent at any time.
Right.
And just because somebody agrees to engage in a sexual act with you doesn't mean that you can just, go to
Assume,
town and do whatever. It's like you still have to make sure that...
But importantly, up till like a year ago, any type of evidence of advanced consent was deemed to be irrelevant. So if you had been messaging with somebody you're meeting up with and discussing what you wanted to do sexually, that would be irrelevant. And it was argued many times by certain law school professors or others that it just leads to discriminatory reasoning.
Right.
And people who express fantasies in text messages, particularly women, don't want to follow through with them. And therefore, it is an incorrect basis in which to try and have any relevance to consent. Yeah, no. Thank God for Reimer, thank God for Justice Petracco, that it does have some relevance to whether consent was given at the time of the sexual act. And so that messaging has some relevance. And that's by just natural logic and common inference based upon how human beings interact. So thank God for that decision.
Yeah,
And I think it's on appeal to the Supreme Court of Canada.
It is.
Yeah, it can make something more or less likely to be true if you know what discussions took place about the sexual acts that they were willing to consent to. But it doesn't tell you if they actually consented at the time.
No, but I want to be careful about more likely. I think what's more interesting is if you're talking about certain things that then tends to be almost script-like as to what you actually do at the time. It has more logical probative value as to whether consent was given, communicated at the time, and it has a degree of relevance and logical probability. I don't know another way of sort of somehow discounting it. I think it's extremely important and relevant.
No, you covered. Okay, let me throw a wrench into this for both of you because I've had this scenario. Client comes to me, high net worth, comes with his parents.
Did you have to say that?
High net worth?
Snob.
I know. We would like you to draft a consent contract for our son so that any female he has contact with, she has to sign it. And these are the check boxes for the type of... It was down to very particular graphic sexual activity. 3 pages they wanted. Drafted in detail. I consent to this, but I don't consent to that.
But this can apply to certain people who've come to us who are actually budding young athletes.
Well, that was
on their
case.
way to...
Yes. Well, this was a budding young.
Yeah.
So what happens there?
So the problem is that it's has some probative value.
It does.
But
Get the contract.
Yeah.
But it doesn't mean that just because somebody checked a box that they have to fulfill that act. It doesn't mean that you can do that act regardless of any
Nor
other
does it mean there was communicated consent at the time. But thanks to Reimer,
Yes.
if you have a contract for consent that describes in detail sexual acts, it's some evidence.
It's some evidence.
It's not going to be a protection, but it will be some evidence that could be relevant at a trial. And we can understand, we've spoken about this before, those who are at some risk because of celebrity status or sports status, and we've had this with a few people, particularly, budding young athletes who are going to make it to
NBA, etc.
to the NBA, baseball, or particularly hockey in these cases.
Right.
They may want this ahead of time because they can be targets.
Yeah.
What about recording consent? Because the other issue is recording
Well, we'll
consent.
get to that in a second, but that just reminded me because of the, athletes or celebrities and things like that. One of the things that can vitiate consent is if you're in a position of power, authority, or control. Right. And so that has been something that's very difficult to navigate because there have been claims made that celebrities, people who are wealthy,
they're in power,
have power and control over people in a lesser position in society.
Yeah, and that, thank God, has not gained the traction that they wanted it to. It just doesn't.
But it's still an argument that, has been put out on social media a lot.
Let's talk about traditional positions of power, just since we brought it up. employer-employee.
Teachers, coaches.
Coaches,
Religious
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 leaders.
leaders.
Yeah.
You know, that type of stuff. I understand those dynamics. Even within those dynamics,
Parental figures, obviously.
Right.
yeah, which is a whole other thing.
That's
But
all, yeah, separate.
but within these dynamics, you can still, you know, establish that in fact there was no power imbalance, that in fact they were both consenting individuals, and because of their position vis-a-vis their relationship, it did not vitiate consent. But that is an important factor to consider, because you can have sexual exploitation based upon these powers and authority, and that's what that provision is for, sexual exploitation.
Now, the recording, that kind of ties into what you were talking about, people wanting to set up contracts. This is a big question. Is there something I can do to protect myself from a false allegation?
Which
How
was the
can I
other part of
establish
what this
consent?
viewer asked. So I think we should examine this. Now that we've looked at consent a little bit, what can you do to protect yourself, whether you're a male or female, on this?
It's a big saying online, especially in men's communities, to say always be recording. But we've mentioned that can get you into trouble, because you could then get charged with voyeurism.
So let's talk about what recording we're talking about. We're talking about visual recording versus audio recording.
Yeah, audio recordings are more helpful and less dangerous, but they have to have some context. I mean, you have to establish that it's that person's voice.
Right.
Right. So you need to have some sort of lead in, and you need to also establish that this wasn't just sort of a little clip. It's going to have something substantial enough to actually indicate and prove that this is the person in question, and that the person understood what they were being asked.
So if you have an audio recording, let's go basic.
Yeah.
They're recording a conversation about the acts they're about to do.
Advanced discussion.
But in a few minutes.
Okay.
Okay. And they're talking. That is highly relevant. You can identify the voice, like any of us who've done drug cases in the past where you've done wiretap evidence and you identify voices, right?
Right.
You can identify a voice by a person testifying and then compare it to the actual recording. And then you can have the person who's the accused testify, say, no, that's them. So you can authenticate it that
Yeah,
way.
that's not a huge hurdle.
But if you have a recording of a discussion about consent of which you're about to engage in, highly compelling, admissible.
Now, obviously, the video is more identifying, because you'd actually have the person on video.
Let's just talk about audio for a moment. That would be helpful. Now let's say you don't have that, but you're recording a portion of the intimate contact. Well, that in and of itself won't run afoul of the criminal law like it would be if it was a video recording. And it may be that there's enough recording, given what is said and what is heard between the parties, that you could maybe identify the complainant in the case, and therefore it would be some objective evidence supporting the accused evidence that there was in fact consent, and could be used also in cross-examination to undermine the credibility of the complainant to say that there was no consent. So again, that would be helpful. Okay? From there then, you go to video recording. What's the problem with that? Because it's a big problem.
Go crazy.
Somebody's physical image is considered to be a very intimate thing for them. It's highly identifying, and also videos and photographs can then be disseminated.
Distributed.
So they can be sent via text message to unknown people. They can be uploaded to the internet on a variety of platforms.
Posted on all sorts of platforms.
And so the invasion of privacy is considered to be extremely high when you're taking video. I mean, you can get video that is consented to, but then what you do with that video is, still quite dangerous.
The distribution.
So let's
piece.
break this down for a second. So if you're with a partner and you're about to have intimacy, you can say, can I record this
Right. Step
by way
one.
of video?
Right.
Yes, that would be fine. And get that consent on video.
Yeah, presumably.
You then, and then if the person is engaging in such a way that they are clearly acknowledging and aware of the video recording, you're establishing consent to the video recording, and you may be then fine with respect to the criminal law, because if there's no consent to the video recording, that video recording in and of itself can lead to a finding of sexual assault. We've done this on a podcast. We went over the case law.
Rockburn case from Ottawa.
But if there's a video recording that the person consents to, and then in the recording, because we've seen this, there's enough evidence to establish the person is not only aware, but they're playing up to the camera, then you're going to be on safe grounds. Right. If you do not have the prior consent of the individual to video record, and you want to use that later on to establish your innocence, you may wind up establishing that in fact Well, they were consenting to do the actual act, but they weren't consenting to the video, so you're still going to be convicted of a sexual assault.
Terrifying.
No, just
Or
stop.
voyeurism.
Everybody
At
think
least.
about that for a moment.
That. That's terrifying. That's the Ottawa
Let's
case.
say you never posted that video anywhere. It just was kept. Okay? You didn't post it. It wasn't done for coercive purposes or to share or distribute in any way whatsoever. You just kept it. Not even for your own archive. I just fucking kept it. And then later on you get charged and you say, well, here's a video recording and we were consenting.
Now, there is an interesting new case.
Is there no exception for that?
Well, so there was a discussion about voyeurism as a charge in a case called 𝐕𝐃𝐿 2024 ONSC, so it's Superior Court 6658. And this was a summary conviction appeal. Yeah. And it was sent back to retrial on the voyeurism charge. And there was an interesting outline about it saying that just because it's surreptitious and the person didn't know it was being recorded, that doesn't necessarily make you guilty. There's also a factor that, the person needs to have a reasonable expectation of privacy.
So location.
Yeah, so say washrooms and things like that. It's like, obviously you don't expect that to happen.
Yeah.
In this case, the complainant was engaged in a sort of long-term BDSM relationship, was blindfolded and had a bunch of other things going on. There were other charges involved, but the video that was made on that count, they hadn't proven that she had a reasonable expectation of privacy given their arrangements and some of the agreements that they had in place. So that is an interesting factor that,
Yeah, but it doesn't really help for the question that was posed because, we're talking about the common instance where you're in a place where you would have a reasonable expectation of privacy, a bedroom, a living room, somewhere within a house or an apartment, and therefore you would have a reasonable expectation of privacy. But for some reason or another, you're recording your interactions of intimacy for protective purposes, not for dissemination, not for posting whatsoever. But the quandary that you're in is once you produce that could lead to a conviction. Yeah. And on a moral basis, if you disclose it to the Crown to say for pretrial purposes, on a without prejudice basis, I'm providing you with a video that shows the complainant's lying. The complainant clearly consented. Here's a video. Take a look. You can see the complainant's lying. You can do that on a without prejudice basis that the video will not necessarily then be used, but the problem is the video itself is real evidence of an act.
That's right.
So it's not real evidence necessarily of the crime that the complainant is specifically identifying.
Right.
Right?
Right.
But it is real evidence of a crime because you video recorded it without their consent.
Right. Right.
It is a very, very difficult area of law now.
Right.
Yeah, it can be. And you also have to keep in mind, too, not to be depressing for people who are legitimately just trying to figure out how to navigate,
themselves,
that there is no statute of limitations in Canada on bringing a charge forward. So how long are you going to keep all these videos?
Yeah, every single date.
Yeah. So
that's a lot.
That's the question, too, is you can have the video and then, you chuck it out and then all of a sudden next year.
Yeah, hello.
Or 35 years later.
Or 35 years later, yeah.
Look, the reality is that the majority of times people interact in a loving and caring and supportive way, and this never happens. We just happen to see the bad side of life, right? So it's a narrow portion of what happens in reality. Right. But we do have people who write us and comment to say, I'm concerned as a young adult, and I'm out there and I like to, date and have fun and we can't give them advice. But video recording without consent can lead to a conviction.
Audio recording safe.
Maybe, but I think it's safer.
In Canada, you don't need the consent of the other person to record a private conversation.
Correct.
In the States, you do.
That's correct.
Right.
That's a good point to make, too, because we do have people in the States that watch.
And there's no tariffs on audio recording yet.
Not yet. Soon.
Maybe tomorrow.
Yeah.
Tomorrow's the
And
2nd.
I think there's got to be a little bit of common sense on the part of, people when they're out at bars and stuff and in places where people are getting extremely intoxicated to just be a little more cautious.
Young people.
I think, if the person who was asking for us to do this, everybody has to be reasonable, has to be tuned and alert to who your partner is at the time, and be cautious. If somebody's intoxicated, it's not a good choice.
Not a good choice.
And have more care for that individual and respect for that individual they're not in their best state to make that decision, especially if you've just met that time. I think times have changed where, it's best to know your partner.
Definitely.
Yeah, we're
It's a
definitely
dangerous
getting there.
world right now, as we know from the number of young men we get charged.
Yeah.
Yeah, and we're not making a value judgment.
No.
I struggle with this because there are, humans are humans, and people want to interact in various different ways, male, female, or whatever your gender is.
Right.
And people enjoy all sorts of circumstances. So who are we again to invade the bedroom? Right. And that's what I've always said about the government. We don't want anybody victimized.
Right.
And I just think, we need a heightened degree of sensitivity and cautiousness and being attuned to the person you're with and taking those steps to ensure that you have what you think is communicated consent. Problem is that won't insulate you.
No.
Stuff happens, and there's no foolproof way of protecting yourself necessarily. But we've tried to review the law, and we just want to give caution about what clearly is illegal.
You mentioned the university environment. What are you... Talk to me about that.
We have children who are university age.
Yes, we do. What are they getting wrong?
Well, I think by and large they're doing it well. They're doing it right now. And I think the universities, we can vilify them. I think there is extreme value in first year orientation about sexual interaction.
Yeah, for sure.
I don't think it's good to misinform students about intoxication. I think what they should say is, an intoxicated consent is still consent, and there are elements to that. However, the best approach is not to engage when you know the other person is intoxicated or you are so intoxicated.
Right.
And you should be aware of that. But the advice generally is, if you're drinking, don't.
That's simple enough.
I would also
Just
add,
don't.
for the university classes, they give courses on consent that you have to take for orientation and stuff like that, and they're mandatory. But I really would like to see them move in the direction of teaching women how to be a little more responsible for their actions as well, because really the problem is they're teaching consent on a model of what they would like to see, not based on what the law is. And
we've seen in cases
interesting,
that
yeah.
we've done, which are not like just a few, that there's a complete lack of agency on the part of the complainant. A complete lack of agency.
Yeah.
Like an abrogation of agency completely, it's going to be the accused's fault. That said, I don't think it's bad for the education. I just think it has to be balanced, appropriate, and in tune with the law. And I think people have to be cautious when they're in university. They're young. They're away from home sometimes for the first time.
Right.
Yeah.
It's an exciting experience, and you can get carried away. Be careful, be mindful, respect each other, and don't take chances.
Right.
But it's a topic that we've talked about before, but I'm glad that it was asked again, because it's just something that people need to keep being reminded about. And also because, case law does come out that can start changing exactly how they're interpreting consent and stuff. And it's important for people to stay up to date on what the law actually means when they talk about consent. So it was a good question.
Yeah, it was. And again, let's just, because we're getting into pillow talk, again, I'll say it ahead of time. Thank you very much for the questions and comments that come in, because it drives some of our content. And I think these refreshers are really helpful. Yeah. So thank you. And
don't forget to like, comment, subscribe,
can
share.
we do it in our backwards way for the pillows that Michael had made?
Backwards way? What does that mean?
Does
Well,
the
'cause
cameras
I think-
reverse it?
Shouldn't we say like,
so.
share, and
Oh, I see.
subscribe, or
Oh, you're
Anyway,
pushing your luck.
Do all of
comment,
these things. And
do
remember,
all these
Just
things?
do everything that's on the
Thank you
pillow.
very much.
and remember
Yeah.
to hit notifications.
Thanks for your viewership.
I think
Good
we
night.
need a new pillow.